Now that we have reviewed the foundational principle laid down by the Supreme Court before 2013, the era of Vishaka guidelines, let us look at how the judiciary has consolidated and clarified the law after the enactment of the Sexual Harassment of Women at Workplace Act in 2013, which runs parallel to the penal offences under BNS Section 75. These cases define the modern application of the law. First, the landmark judgment in Aureliano Fernandez versus State of Goa. This case is perhaps the most significant recent development as it shifts the focus from simply having the law to its enforcement. The Supreme Court noted serious systematic lapses in the implementation of the POSH Act across the sectors, public as well as private. As a result, the court issued mandatory time-bound directions compelling all government bodies, universities and statutory organizations to verify the constitution of their internal committee and crucially publish their details on websites to ensure transparency and accessibility for the aggrieved women. It was a powerful step towards institutional accountability. Second case we have is the case of Punjab and Sindh Bank versus Durgesh Kuwar. This is from 2020. This judgment provided essential procedural clarity on interim measures. It reaffirmed the power of the internal committee and the employer to reorder the transfer of the respondent, the accused, during the pendency of the inquiry. The court underscored that this measure is often critical to maintaining a safe work environment for the complainant, preventing further victimization and ensuring the fair process. Why are we discussing these cases under POSH Act here? We are discussing these cases here because Section 75 of BNS runs parallel to POSH Act 2013. BNS governs the criminal prosecution of the offender. The POSH Act 2013 governs the civil and administrative inquiry within the workplace. Both avenues can be pursued simultaneously for the same incident. Please have a look at this slide. Third case we have here is the Delhi High Court's ruling in Shanta Kumar versus CSIR. This case helps refine the definition of harassment. The court rightly observed that not every argument, rude comment, or even inappropriate physical contact in the workplace automatically constitutes sexual harassment. To affect the provision of POSH Act and by extension the criminal provisions of BNS Section 75, the contact or remark must possess a clear sexual undertone or a sexually colored intent. This prevents the law from being misused for non-sexual workplace grievances. The important thing here to note is that any derogatory remark must carry sexual undertone or must be sexually colored. That's all for Section 75. Let's move to Section 76. Assault with intent to disrobe. We now look at the aggravated offense of assault with intent to disrobe, Section 76 BNS. The section reads as assault or use of criminal force with intent to disrobe. Whoever assaults or uses criminal force to any woman or abates such act with the intention of disrobing or compelling her to be naked shall be punished with imprisonment of either description of a term which shall not be less than 3 years but which may extend to 7 years and shall also be liable to fine. As you can see, this is a specific offense targeting acts of public or private humiliation using nakedness as a weapon. The essential ingredient of this section, Section 76, Bharatiya Nyaya Sanhita, involves assault or criminal force against a woman. Covers the act which target women by doing acts in public and private to humiliate her. Section 76 deals with a very serious and specific type of assault that goes beyond general sexual harassment. Essentially, this law punishes any man who uses force or physical attack against a woman with the explicit and the only goal of removing her clothing or forcing her to be naked. That is to disrobe or compel her, force her to be naked. The offense is complete the moment the assault or criminal force is coupled with the specific intent. When the offense gets completed, when assault plus criminal or criminal force is coupled with intention. It is not necessary under this offense that woman is successfully disrobed or made naked for the offense to be proven. The attempt coupled with intention is sufficient. This offense is treated with high severity because it is not just about general sexual misconduct, it specifically targets public or private humiliation where nudity is intentionally used as an act of dominance or as a weapon to outrage her modesty. One thing should be noted here is that this section uses the term whoever. This section uses the term whoever assaults or uses a criminal force. A gender neutral term is used for perpetrator. The victim remains a woman. Let's look at the punishment of assault to disrobe, section 76. The punishment. The law is very strict here. It mandates a minimum of 3 years of imprisonment, extendable up to 7 years. Minimum is 3 years, which can be extended up to 7 years, along with fine. Imprisonment plus fine, both. Minimum 3 years or maximum 7 years. Let's talk about its procedural nature. It is cognizable in nature. We already know what cognizable is. An arrest can be made without a warrant and investigation can be made without a magistrate's order. It is non-bailable in nature and it is triable by court of session. One important case law on attempt to disrobe here is one important case law on attempt to disrobe we have is Pema Shering Lepsha versus State of Sikkim 2024. This case helped us understand how court establishes that necessary intention. The allegation was that the accused tried to pull down her trousers. The court held that that this physical action directed specifically at removing clothing is sufficient prima facie evidence to demonstrate the intention to disrobe required by the statute. That is, the attempt to pull down the trousers provide a prima facie basis to establish the intention of disrobing as required by the section. The next offense we are going to discuss here is the offense of voyeurism. Voyeurism is the practice of gaining sexual pleasure from secretly watching others during private activities. Section 77 of BNS deals with the offense of voyeurism. Let's read the text of this section first. Whoever watches or captures the image of a woman engaging in a private act in circumstances where she would usually have the expectation of not being observed either by perpetrator or by any other person at the behest of the perpetrator, or disseminates such image shall be punished on the first conviction with imprisonment of either description for a term which shall not be less than 1 year but which may extend to 3 years, and shall also be liable to fine and be punished on a second or subsequent conviction with imprisonment of either description for a term which shall not be less than 3 years but which may extend to 7 years and shall also be liable to fine. The first half of this section defines what voyeurism is and who can be an offender and who can be a victim. The second half of this section deals with the punishment part, which we will deal with later on. Here the word whoever is being used for the offender. It means anyone can be an offender. It means anyone can be an offender. It is a gender neutral term, while the victim can only be a woman. So let's look at the next slide to understand voyeurism in a better way. Voyeurism. The essential ingredients that can be derived from the language of section are: first one is there should be an actus reus. That is, the guilty mind should be there while doing the offense. It involves two main actions. First, watching or observing a woman doing a private act, or capturing an image or video of the woman or any other form of imagery doing the of woman engaged in private act. The first essential is actus reus. It involves watching or observing or capturing via image or video. The second essential is mens rea, that is guilty mind. There should be a mens rea. There should be a guilty mind. The offender must have the intent to violate such privacy. There should be an intent to violate the woman's privacy. This includes act where there were no original intent to share such content but was formed later on. We'll explain this later on. The third essential is lack of consent. The act must be without her consent, without the victim's consent. Such act of watching or capturing must be without her consent. The next essential is reasonable expectation of privacy. The act must occur in circumstances where the woman would reasonably expect to be unobserved. This situation includes using restrooms, changing clothes, or being in a place where one typically expects privacy. The next essential ingredient is dissemination of the offense. This offense also extends to sharing or disseminating the captured images or videos, regardless of whether the initial capture was with consent. The next essential ingredient here is dissemination of the offenses. Dissemination means spreading or circulating. So this offense also extends to sharing or disseminating the captured images or videos to third party, regardless of whether the initial capture was with consent. And this includes let's see a common example. A common example of this would be uploading private or intimate photos or videos to social media sites like Facebook, Instagram pages, or any dedicated pornographic website. In such a case, it doesn't matter whether the initial capture or initial image was taken with consent or without consent. If it's being disseminated, it is an offense. It is an offense. Let's see the punishment for the offense of voyeurism. The punishment is divided into two parts. The first one is those who are convicted for the first time. So the first conviction, here the imprisonment can be of 1 year, which can be extended up to 3 years. Along with imprisonment, a fine would also be imposed on the offender. So imprisonment plus fine. Imprisonment 1 year to up to 3 years. This is an enhanced punishment. There is an enhanced punishment in this also. It is for repeated offenders. For people who are committing the offense for the second time or third time. So if the conviction is for the second time or subsequent times, the punishment would be minimum 3 years, which can extend up to 7 years along with fine. So imprisonment plus fine, and imprisonment would be minimum would be 3 years, maximum would be 7. Here for first time conviction, minimum would be 1 year and maximum would be 3 years. Let's take a look at the procedure of the offense. The procedural aspect of voyeurism is also tiered like its punishment aspect. Cognizable. It is cognizable. We know what cognizable is. When it comes to the matter of bail, one important thing to note here is that the first offense of voyeurism is bailable. First offense is first time, it is bailable. For the second or subsequent offense, it is non-bailable. So, for the second or subsequent times, the punishment is also enhanced and the bail is also denied. Which court can try this offense? It is triable by Court of Session. Court of Session. Here's the case law on this. Please look at your screen. State versus Shailesh 2019. It was determined in this case that while voyeurism may be a cheap form of amusement, silly form of amusement for men, it traumatizes women mentally. These actions violate a woman's right to privacy, making her feel insecure in settings that are typically designed to be safe for women. Offense number 5, which we are going to discuss, is the offense of stalking. Stalking means unwanted pursuit. Let's read the language of the text first. Any man who follows a woman or contacts or attempts to contact such woman to foster personal interaction repeatedly despite a clear indication of disinterest by such woman, or monitors the use by a woman of the internet, email, or any other form of electronic communication, commits the offense of stalking. Provided that such conduct shall not amount to stalking if the man who pursued it proves that it was pursued for the purpose of preventing or detecting crime, and the man accused of stalking had been entrusted with the responsibility of prevention and detection of crime by the state. It was pursued under any law or to comply with any condition or requirement imposed by any person under any law. And in particular circumstances, such conduct was reasonable and justified. Let's read the clause 2 of stalking. Whoever commits the offense of stalking shall be punished on first conviction with imprisonment of either description for a term which may extend to 3 years and shall also be liable to fine, and be punished on second or subsequent conviction with imprisonment of either description for a term which may extend to 5 years and shall also be liable to fine. We will discuss the punishment for stalking in the later slides. So let's see what stalking is. Stalking under Bharatiya Nyaya Sanhita, section 78, punishes a pattern of unwanted pursuit. The law defines it with 2 primary acts, both of which must be repeated. The first one is physical act, following or contacting or attempting to contact to foster personal interaction despite a clear indication of disinterest. The second one is electronic monitoring a woman's use of internet, email, or any other form of electronic communication. Example of this would be repeated and unwanted communication by phone, mail, text, etc. The law on stalking, section 78, provides specific exceptions where a conduct is not stalking, such as when monitoring or following is pursued for preventing or detecting crime by an authorized person or pursued under any law, or to comply with a legal requirement. Let's take an example. A police officer conducting surveillance on a suspect in an investigation would be covered by this exception. And the condition to satisfy the exception part is that the conduct must be reasonable and justified in the particular circumstance. Another example can be taken of this. A private investigator hired to gather evidence for a legal case such as an extramarital affair, provided that the conduct is reasonable within legal bounds. Let's talk about the punishment for the offense of stalking. Similar to voyeurism, the punishment for stalking is also tiered and enhanced for repeated offenders. The punishment for first-time offenders, the punishment for first conviction is imprisonment up to 3 years. Along with imprisonment, a fine shall also be imposed. So up to 3 years plus fine. For the second and subsequent convictions, there is an imprisonment which may extend up to 5 years along with fine. So up to 5 years plus fine. Let's see the procedure. It is cognizable in nature. First time offense is bailable. Second or subsequent offense, similar to voyeurism, is not bailable. It is non-bailable and it is triable by any magistrate. One of the case laws on the offense of stalking, to understand the concept of stalking, one of the case laws on the offense of stalking, to understand its concept, is the case of Inspector General of Police versus Samuthiram, 2012. The emphasis was made on the significance of addressing complaints by victims and onlookers concerning incidents of evening taunting and harassment in public spaces, including transit system, schools, theatres, and other locations. Now we are going to discuss the offense of insulting modesty. Insulting modesty is covered under Bharatiya Nyaya Sanhita, section 79. Let's read the section first. Words, gestures, or act intended to insult modesty of a woman. Whoever intending to insult the modesty of any woman utters any word, makes any sound or gesture, exhibits any object in any form, intending that such word or sound shall be heard or that such object shall be seen by such woman or intrudes upon the privacy of such woman, shall be punished with simple imprisonment for a term which may extend to 3 years and also with fine. This section, insulting modesty, deals with non-physical insults and is often referred to as eve teasing. Non-physical, that is eve teasing. Eve teasing is a common name for it, not a legal term. This section punishes whoever intending to insult the modesty of a woman utters any word, makes any sound or gesture, or exhibits any object intended to be seen or heard by her or intrudes upon her privacy. There is a distinction from section 74 of Bharatiya Nyaya Sanhita, which is outraging the modesty. Section 74, which deals with outraging the modesty, requires physical force or assault. Physical component is necessary. Section 79 is non-physical in nature. It requires words, sounds, gestures, or objects to insult the modesty of any woman. Section 79 criminalizes deliberate actions aimed at insulting the modesty of the woman. This includes any verbal acts. Like uttering words with intention to offend or demean a woman's dignity, or making any gesture or sound with the intention that says such gesture or sound, when perceived by the woman, would cause embarrassment or discomfort. For example, a man standing outside a woman's window and making obscene gesture, or a person making vulgar comments about her in a public space with intent to insult her modesty would come under this offense. One of the essentials is also exhibiting objects. Displaying objects in any form with the intent that they be seen by the woman, leading her to humiliation. For example, showing offensive pictures to a woman. Privacy intrusion is also an essential element. Entering or observing a woman's private space without consent, aiming to offend her sense of modesty, would constitute the offense. Privacy intrusion, entering a woman's private place without consent with the aim to offend her, would come under this offense. One of the things to note here is that this section uses the word whoever for the offender. This whoever, anyone, this means anyone can be an offender. It doesn't necessarily has to be a man. However, the victim here also can only be a woman. The essence of this section lies in the intent behind the act, even if the action does not result in physical harm. The deliberate intention to insult the modesty of a woman is sufficient for the act to be punishable under this provision. This broadens the scope of protection so that the women are safeguarded against various forms of harassment, including those that are non-physical but equally degrading. Let's look at the punishment part, which is given in the later part of section 75. The punishment includes simple imprisonment up to 3 years along with fine. So simple imprisonment up to 3 years plus fine. This is the simple punishment of insulting modesty. Let's look at the procedure. It is cognizable but also bailable. Cognizable along with bailable, and it is triable by any magistrate. Please take a look at this slide and see the offences we have discussed and their procedural nature. So let's move to the conclusion part. Let's conclude. It can be said that Bharatiya Nyaya Sanhita is a continuation of the existing law. There are no radical changes. The core legal protection established in 2013 are intact. The new structure under Bharatiya Nyaya Sanhita, section 74 to 79 is logical and groups related offences together. Also, it can also be said that Bharatiya Nyaya Sanhita is a comprehensive law. The framework is robust. It covers physical, electronic, verbal, privacy-based offences. However, we must observe that there are some challenges in its enforcement, investigation, and societal implementation which need to overcome. So that's all for today. Thank you.